And welcome back to Law and Society. This is where legal and social issues come together. Andrew Stevenson is attorney at law, criminal defense attorney right here in Lancaster. Again, StevensonCriminalDefense.com if you want any information, or heaven forbid, you need his services. Just remember, I want a lawyer.
Yes.
And that's what we're talking about today is Miranda.
Right. And as we covered in the first part, Miranda applies. You must be read your rights if you are in custody and you're going to be subject to questioning, and they want to use what you say. So the question becomes, in custody, what does that mean? Well, obvious answer is if you are placed under arrest, told you are under arrest, and they put the handcuffs on, you're in custody.
Right. But as you said in the first half, at that point, they do not necessarily have to read you your rights.
They don't have to read them to you, but then if they ask you questions, they can't use your answers against you.
Right. Until they read you your rights.
They read you your rights, yes. And if you've been arrested and you're in jail, you're in custody. If you are in the police station, in the interview room, you're in custody. You are not in custody when you have what's considered a consensual encounter with the police. So if they come to your house, knock on your door, we'd like to come in and talk to you for a little bit about the incident that occurred last night, they don't have to read you your Miranda rights because you're not in custody.
Okay.
The idea has always been that the custodial interrogation is inherently unfair, that the police have an advantage.
Yeah.
You're under their control. You're in a room. They are law enforcement. They have badges. They have guns. They're intimidating.
The very location is intimidation. Yes. Right? You're in a room that's beyond your control.
Right. You can't leave. That's why these safeguards, the Supreme Court in the Miranda decision wanted safeguards, which basically said they have to at least tell you you don't have to talk to them.
Right.
So, in a consensual encounter, they don't have to read your rights, but everything you say can be used against you. Phone calls, when they simply call you up and want to speak to you about the incident that happened last night, or when your accuser calls you up and tries to extract a confession and they're on the other end recording you, they don't have to read you your rights because you're not in custody.
Are there any wiretapping issues that say they have to tell you they're recording? No beeps or anything to tell you?
No.
Okay.
And so now if they call you up when you're in jail, that's another story because you're in custody. Now that doesn't happen, but for a point of argument, it could.
But are they allowed to monitor your phone calls if you're in jail?
Oh, not only are they allowed to monitor, they do.
Okay.
Every single phone call that is made coming from the jail is recorded. Now, it's not only recorded, but it is then sent in some counties to the prosecutor's office within 2 minutes of the phone call ending.
Wow. So there is zero expectation of privacy.
Zero.
What about between a lawyer and the client? I want to confer with my client. Do you have the right to privacy then?
It's a complicated issue that we can address at a later show.
Okay.
That's
a whole nother show.
That's a whole nother
itself.
show. Yeah.
Wow.
Yeah.
See, that's gonna be number 11 on your list.
That's a complicated issue.
All right, but the bottom line is, don't be talking on the phone thinking you have privacy if you're in jail. That payphone is being monitored.
It is being recorded and it's being sent to the prosecutor. Assume the prosecutor or detective is sitting next to you when you make your phone call.
Gotcha. Okay.
Auto stops are the same way.
Yeah,
now,
this is a sticky wicket
This
here.
is sticky. And the Supreme Court over time kind of struggled with this issue because, yes, you've been stopped. The little lights came on.
Right.
You've been pulled over. The officers come up to the window, and they're going to ask you questions like, do you know why I stopped you? Have you been drinking? Is there anything in the car I should know about? All of which the answers could be incriminating. Yes, I have been drinking, and yes, I do have marijuana in the car. But the basic answer is they're not required to read you your Miranda rights at that time because it's quote unquote simply investigative, not custodial interrogation. But that's the answer. Whether or not that's true or not, there it is.
And and again, DUI stop or just routines. They're supposed to have a reason to stop you, right?
Correct. Probable cause.
But that probable cause could be you went left of center for a half a second.
And that's the issue of citation.
Yeah.
It gets a little tricky when they put you in the back of the cruiser to search your car.
Now you're in. I would think you're in custody. You're now in a confined environments.
There's a lot of cases that go back and forth on that.
Okay.
And they're allowed to put you in there for their safety and their protection. But then if they come back to the car and ask you a question while you're in there, but they haven't advised you of your Miranda rights,
Right.
that's where it's a case-by-case analysis that's
Right.
done.
Okay.
And the exception to all of this, which is interesting, is if they send an undercover officer into jail or prison,
Okay.
which they did in a case in Illinois.
So you're talking to your cellmate thing.
Who's actually an undercover cop.
Okay.
And they don't have to give you Miranda, but the guy's just there to try to extract a confession from you. But you're in custody, and you're being questioned by a law enforcement officer, but they don't have to Mirandize you.
Wait a minute. Even if that undercover cop asks you, is he allowed to ask you? And that's still not covered under Miranda?
Illinois versus Perkins, the United States Supreme Court said that was okay.
Again, back to that, and you have no expectation of privacy.
In prison, yeah.
Okay.
The Miranda rule only applies to law enforcement.
Yeah, now this is something I asked earlier, and
it
because,
must be a law enforcement officer.
Okay.
Security guards don't count, and generally probation officers don't count unless they're investigating a new crime.
Okay.
So if you go to talk to your probation officer and they say, "What have you done this week?" and it's just your routine thing, and you say, "Well, I slipped up and I, fell off the wagon, or I had a little slip up with drugs," then that's not considered. They don't have to Mirandize you first.
And the key word there, Andrew, is the fact it's police. So, for example, our Fairfield Medical Center has its own police department.
Correct.
They are a duly authorized
Yes.
police agency. Campus police.
Yes.
Look for the word police. Yeah, and you'll know that they're that it's serious. They can.
But a sheriff deputy volunteer, one of the volunteers,
Community watch,
community
not
watch,
so much. No,
not so much. No.
But deputies are, and the other misconception is that highway patrol aren't real police.
No,
officers.
they're real police.
They're actually
they're They are.
So I've heard that one too. You can't do anything. You're a highway patrol. No, they gotcha. So the mall cops,
they're not required to read your Miranda.
Right.
Now, they have to advise you of your rights. You have to acknowledge it, and there has to be, in the old days, there had to be what was considered a waiver. So sometimes we get issues involving whether or not what language they're read to. Deaf people, if someone's passed out, they can't just read your rights if you're passed out.
What if you're intoxicated and that you're still under the influence?
There's supposed to be an acknowledgement of the rights is what's required. There's supposed to be, I understand my rights. Thank you very much. In 2010, or prior to 2010, there also had to be a waiver.
Okay.
They had to demonstrate that the person waived their right to remain silent and waived their right to an attorney. They used to do that through a piece of paper that they would sign, where they would initial all of their rights, and then they'd say, "I give up my rights,
my rights,
and I'm willing to talk to you."
But back to a point at the beginning, which said that Miranda, you can re-invoke your rights at any time, right?
Yes, you can start a conversation and say, "I'm sorry, I don't want to talk to you anymore."
Yeah. Okay.
I've had a case where people have said they don't want to talk 7 times. I don't want to speak to you. The cops kept on questioning. I don't want to speak to you. They kept on questioning. I don't want to talk to you. The magic phrase, however, things change when you say, "I want a lawyer."
Right. So 2010, what changed in 2010?
In 2010, there no longer needs to get a release.
Okay.
A waiver.
A waiver.
Yeah.
Okay.
The Supreme Court said if they talk, it's a presumed waiver. So if they read you your rights and you start talking, then it's presumed that you want to talk, therefore it's voluntary.
Okay. So you've implied the waiver.
You've implied the waiver because you talked. Yeah.
Aren't we back to
exactly where we were before we started with 1966? So
right.
we were right prior to Miranda.
Yeah.
The only exception is the phrase, "I want a lawyer."
That's the 4 magic words.
That triggers a whole series of new rules. If you say you don't want to talk to him, there's a set of rules. But the real rules are, whenever you say, "I want a lawyer," no matter what the situation, where you are, certain things have to happen.
Never ask, "Do you think I need an attorney?"
It has to be a clear request for an attorney.
Right.
I want a lawyer. Get me a lawyer now.
Now.
I want to speak to an attorney. I want one here. Things like, "Do you think I should get a lawyer?"
Yeah.
Does that sound like a good idea?
No.
Do I really?
Come
I need
on,
an attorney?
Seriously, do I
That
need
doesn't
one?
work. It
No.
has to be, "I want a lawyer." And once it's clear, 2 things happen. One, all questioning must cease immediately, and it cannot resume unless the suspect demands to speak to the police and then signs a voluntary waiver.
Okay.
So
again,
if you don't know what to do and you're in any situation involving law enforcement, and you are uncertain of your rights, 4 simple words.
I want a lawyer. So then what happens when the police officer says, okay, get him a lawyer? Why are you making this so hard on us? You know, if you're innocent, why do you need to? Are they allowed to, like,
legally?
They're not questioning you necessarily. They're just basically starting to talk at that point.
Legally, no. I had a rather high-profile case once where the person was in jail and had been there for a while, and his conscience kind of got to him. And he said he let the jailers know that he wanted to talk to the police, and the police picked him up, took him down to the station, and he said, listen, I'm going to give you a full confession here. And so dutifully, the officer went through and said, well, let's give you your Miranda rights just to make sure we do this right. And in the middle of it, the guy said, you know what, I think it'd be a good idea. If we got a lawyer, I'd like to have a lawyer here. Now, he wanted a lawyer so that it would be official and that his confession could be not undone. But it was midnight, and so the police didn't know what to do. So they started making phone calls to different attorneys. He gave them names, including mine. I wasn't in my office at 12:30 at night. And in the end, he said, oh, forget about it. I'll go ahead and tell you anyways what happened. And it turns out that because he said at the very beginning, yes, I would like a lawyer here, all questioning should have stopped.
Inadmissible then.
Inadmissible, and the confession was thrown out.
What about juveniles? If you're under the age of 18, do the police have the right to question you without your parents being there?
Yes. The person who's being questioned has to invoke the rights.
Okay.
So if you're questioning a 10-year-old kid, he has to invoke the rights, and the police are allowed to question him without their parents.
There's no age limit, low age limit that says
you can question a 2-year-old if you want.
Wow. Okay. But that 2-year-old would have to say.
But the 2-year-old they have to demonstrate that he understood what his rights were.
All right.
And if you can't convict someone under the age of 7 of a crime.
Obviously, very complicated, and more to this, and we're going to get to more to this. But I do want to leave a little time for
to finish the story of the Miranda story
of Miranda. But again, you have the right to remain silent. So the best thing to do is say, I want a lawyer, and then shut your mouth.
Yes.
All right. Let's talk about Miranda a little bit.
Let's talk about Ernesto. So Ernesto, after the Supreme Court overturned his conviction, got a new trial. And this time at trial, the prosecution could not use his written statement. So what the prosecution did is they put in additional evidence and called a few more witnesses and actually put on a real prosecution, not just this piece of paper that he signed. And in the end, he was convicted again, and he was sentenced to 20 to 30 years. However, in the old days, they would give big sentences and kind of let people out early. So he was paroled in 1972. And he got out, and he kind of struggled to make a living. But one of the things he found he could do to make money was sign the Miranda cards.
Autographed Miranda cards.
Autographed Miranda cards. And so he ran around making a living signing these Miranda cards for people that had been created because of his case. Now, he ran into a little trouble here and there with some driving without a license, but eventually he was found in possession of a firearm, which was in violation of his parole, and he was sent back to prison for another year. He got out of prison again, was in a bar one night, got into a little scuffle with someone, and he got stabbed. He was rushed to the hospital, and he was DOA at the hospital. The police had a suspect that they arrested in connection with his stabbing, and when they arrested him, they read him his rights. And he read him the Miranda rights. And the guy invoked his right. And he remained silent and asked for an attorney. And as a result, he was never charged because they didn't have enough evidence. And he eventually fled the country.
This is a Rod Serling ending right here.
It's a Rod Serling. So most people don't know. Unfortunately, Ernesto Miranda, died. The person who killed him was never convicted because
he had invoked his Miranda rights.
There you go. That's the irony of the story of the Miranda case.
Wow. I guess that's one of those, what goes around comes around, doesn't it? Wow, what a show. Okay, so next month or in a subsequent month, we're gonna tackle part 2 of this.
We're going to tackle part 2 of the.
All right.
Speaking to the police.
Again, Andrew Stevenson, criminal defense attorney. If you find yourself hearing those words, Andrew or one like him, but Andrew is that's what you do for a living.
That's what I do for a living.
And again, it's StevensonCriminalDefense.com if you need to get the information. And when you hear that, I want a lawyer. So
Thank you, Mark.
If we remember one thing from today, that's what it needs to be.
Yep.
All right, we'll see you next month.